We are going to start, as we started the last day, with the presentation by two experts who have agreed, and we're delighted that that's the case, to examine the submissions and to present them in a balanced way in terms of the papers you will have already received. Professor Gerry Whyte is an associate professor in Trinity Law School and a fellow at Trinity College. He's one of Ireland's foremost constitutional law scholars, and he's co-authored with Professor Gerald Hogan the latest edition of Kelly's Irish Constitution, a major textbook in Irish constitutional law. And those of you who were at the ceremonial opening in Dublin Castle on the 1st of December will have seen Gerard Hogan give a masterly presentation of the legal basis of the Constitution. So Gerry Whyte is very definitely the right person to have in introducing this topic this morning. And the other person is Professor Siobhan Mullally, Professor of Law in UCC. She has a PhD from the European University Institute in Florence. She's held lecturing positions in the UK and Pakistan and visiting positions at several US universities. She's published widely in the field of gender, sexuality and human rights law, including a book on gender, culture and human rights, Reclaiming Universalism. So it's with great pleasure I ask in the first instance Professor Gerry Whyte to open proceedings.
Good morning, everyone. Thank you, Chairman, for that introduction. Let me start with the good news that my presentation this morning will be brief and will hopefully come within the 10-minute time allocated, simply because the provision that we're looking at this morning, Article 41, Section 2, is not one that has received much attention from the court. So there isn't an awful lot of case law to discuss here. What I hope to do in the presentation is cover 4 points. First of all, say something very briefly about the historical background to Article 41, Section 2. Secondly, look at how it is featured in litigation. Thirdly, consider whether or not there are potential applications of Article 41(2)(2) in future litigation. And then finally, just look at recommendations for reform that have been put out there already. And first of all, just in relation to the historical introduction, well, let's read the clause first of all. The clause reads, "In particular, the state recognises that by her life within the home, woman gives to the state a support without which the common good cannot be achieved. The state shall therefore endeavour to ensure that mothers shall not be obliged by economic necessity to engage in labour to the neglect of their duties in the home." Now, I think it would probably be fair to say that in 1937, that probably was reflective of much contemporary opinion about the way in which society should organise its affairs, and in particular about the role of women. That said, the clause did generate controversy. Gerard Hogan, in his latest book, said that this particular clause and other provisions in the Constitution treating women was the single policy issue which dominated debate on the Constitution both inside and outside the Dáil. And a concern that was pressed very forcibly but to no effect was the concern that this clause might justify the state in pursuing gender discrimination in employment. That was the major concern. Now, in fact, the provision doesn't appear ever to have been cited either in legislation or in litigation to justify such gender discrimination, but at the same time we know that until the 1970s there were clear policies of gender discrimination in employment, such as, for example, the marriage bar in the public service, and clearly this clause would have offered support for that type of policy. In terms of its consideration by the courts, as I indicated a moment ago, the courts have really had very few occasions on which to consider Article 41, Section 2. It did feature in relation to two topics, gender discrimination and then recognising work done in the home. And first of all, if we consider the cases in relation to gender discrimination, Article 41, Section 2 has featured in 4 cases involving gender discrimination, and in two of those cases the clause was applied by the courts to justify gender discrimination. These 2 cases are the cases of Dennehy and the Minister for Social Welfare in 1984, and Louth and the Minister for Social Welfare, the High Court decision in 1994, and then the Supreme Court decision in 1998. And possibly ironically, given the concerns that were there that this clause might be used to potentially oppress women, in these 2 cases the clause was used to justify preferential treatment of deserted wives under the Social Welfare Code. At the time, under the Social Welfare Code, deserted wives were entitled to deserted wives allowance, a means-tested payment, or deserted wives benefit, a social insurance non-means-tested payment, in circumstances where similar payments were not made to deserted husbands. And 2 deserted husbands argued unsuccessfully that this was contrary to the constitutional guarantee of equality. But the courts, both the High and Supreme Court in both cases, took the view that the Oireachtas was justified in making this preferential provision for deserted wives, referring in part to Article 41, Section 2. On 2 other occasions, attempts were made unsuccessfully to rely on Article 41, Section 2 to justify gender discrimination. So in the case of De Burca versus the Attorney General in 1976, in his dissenting opinion in the Supreme Court, Chief Justice O'Higgins relied on this clause to justify the exemption of women from jury service. The majority of the Supreme Court rejected that, and so the automatic exclusion of women from jury service was declared unconstitutional. But Chief Justice O'Higgins did attempt to rely on this clause unsuccessfully to maintain the status quo. In a later case, OG versus the Attorney General in 1985, the High Court also rejected an argument advanced by the Attorney General invoking Article 41, Section 2 to justify discrimination against widowers in the context of adoption. At the time, widowers could only apply to adopt a child if they already had a child in their custody, whereas no such restriction was imposed on a widow. The High Court declared that to be unconstitutional, rejecting the Attorney General's argument that Article 41, Section 2 might justify this discrimination. The second context in which Article 41, Section 2 has been considered relates to recognising the value of work done in the home, and this has usually arisen in the context of matrimonial breakdown, family law cases. There was a somewhat ambitious attempt made by one High Court judge, Mr. Justice Barr, in 1989 in a case called L versus L, to use Article 41, Section 2 in order to create an entitlement on the part of wives to have a share in the matrimonial home, in the value of the matrimonial home in situations where a marriage was breaking up and the couple were separating. That attempt, however, was rejected by the Supreme Court on appeal, who took the view that this was a rather ambitious reform and that it was a reform which really could only be undertaken by the Oireachtas, that it wasn't appropriate for the courts to attempt to effect this change. Chief Justice Finlay did, however, indicate that in relation to the award of maintenance to a wife, that where a husband was capable of making proper provision for his wife within the home, the amount of maintenance set by the courts should be at a level so as to avoid the wife having to work outside the home because of economic necessity. So he did take account of the provision in relation to determining levels of maintenance. More recently, and in similar fashion, in 2002, in a case called DT versus CT, 2 members of the Supreme Court, now Chief Justice Denham and then Chief Justice Murray, cited Article 41, Section 2, subsection 1, in support of the view that when the courts are making proper provision for a spouse in the context of divorce proceedings, regard should be had by the courts to the work of a spouse caring for dependents, the family and the home. Penultimately on this point, in a case called Synod versus Ireland in 2001, which was concerned with the constitutional rights of people with severe or profound learning difficulties, and in which one of the plaintiffs, Cathy Sinnott, was bringing a claim alleging that her rights, constitutional rights as a mother, had been infringed by the state's failure to provide for the proper education of her son. Judge Denham made reference to Article 41, Section 2, and just made an interesting comment. She made the point that Article 41, Section 2 does not assign women to a domestic role. It does not say that that is the role that women have to discharge. What it does is it offers recognition for the significant role played by wives and mothers in the home. Article 41, Section 2 is located in an article that is concerned with the family based on marriage. Notwithstanding that, two judges independently have offered the view, this is Judges Walsh and Judge McCarthy, they've offered the view that Article 41, Section 2 might also be invoked by unmarried mothers, that they wouldn't necessarily be confined to wives and mothers in a married family. While in the aforementioned case of DT versus CT, Mr. Justice Murray attempted what I think to be a somewhat ambitious interpretation of the clause, arguing that it could be interpreted to apply to fathers, that it wouldn't necessarily be confined to the role of mothers in the home. Okay, the penultimate point I want to make is just to consider whether or not Article 41, Section 2, subsection 2 in particular, might be used by the courts to improve social protection for wives and mothers in the home. And sometimes it is speculated that the clause could be used more often than it has been. The late Judge Brian Walsh expressed astonishment in one article that what he called this protective guarantee had not featured at the time he was writing in litigation. And as I've just indicated, it hasn't featured very much in litigation since then. But I'm somewhat pessimistic that this clause could be used successfully in litigation in the courts to oblige the state to improve support, say through the social welfare or tax systems for mothers in the home. And there are two reasons for that. First of all, when you look at Article 41, Section 2, subsection 2, the second sentence in the clause, the duty imposed on the state is stated in a very weak fashion. What the clause says is the state shall endeavour to ensure. This is not the same as saying that the state shall ensure that mothers will not be obliged by economic necessity to work outside the home. So the wording itself is rather weak, and it has been described by one judge as creating a duty of imperfect obligation. So that's one issue with which the courts would have to concern themselves if an attempt was made to try and rely on this clause to improve financial support for women in the home. The second concern I have is not directly related to the text of Article 41, Section 2, but refers to the fact that in 2001, in two cases, the Supreme Court indicated that the courts had no role to play in identifying implied constitutional rights that would have implications for public spending, that would require the Oireachtas or the executive to allocate public monies for the vindication of those rights. And I think that counts against any use of Article 41, Section 2, subsection 2 in this way. Finally, I want to conclude just by drawing your attention to three official reports which have been published and which address Article 41, Section 2. The earliest of these is the report of the Second Commission on the Status of Women in 1993, and that called simply for the deletion of the provision on the grounds that it was sexist. Two subsequent reports, however, have suggested not that the provision be deleted, but that the wording be modified and made gender neutral. So the Constitution Review Group in 1996 considered that the Constitution should recognise the significant contribution made to society by people who care for children, elderly relatives and others in the home. And so they recommended that Article 41(2) be retained, but they suggested a new wording, which was, the state recognises that home and family life gives to society a support without which the common good cannot be achieved. The state shall endeavour to support persons caring for others within the home. And then a year later, a majority of the All-Party Committee on the Constitution, in its first progress report, agreed with the position of the Constitution Review Group, rewording the Constitution Review Group's formula very slightly, just to delete the reference to home and to refer solely to family life supporting society. So that concludes my presentation. Thank you very much.
Thank you very much indeed, Professor Whyte. And now Professor Siobhan Mullally, please.
Good morning, everyone. I'm going to try not to overlap too much with Gerry's presentation, and there's a little bit more detail in the written submission. So I'll go through a little bit of the background to Article 41.2 and then look at some of the key arguments that have been made in terms of possible reform or retaining the provision in its current form. So the provision you'll all be familiar with by now. Again, it's a specific recognition and reference to the role of women in the home and the duties of women in the home. And the second part relates specifically to the position of mothers within the home. Looking at the historical context in which Article 41.2 was drafted, and Gerry has already made reference to this, it's premised on an ideal of separate spheres for women and men, an idea that natural sex differences determined the kinds of roles that women and men should play in society and in the home and in family life. And that idea that women and men have different roles and different duties finds expression in Article 41.2. It's quite an unusual provision in terms of the constitutional text, in that it relates specifically, it assigns specific roles and duties to women and to mothers. It reflects the teaching at the time on different roles for women and men. It reflects a specific influence of Catholic social teaching at the time and the influence of Catholic social teaching on the drafting process of the Constitution. Even at the time that it was adopted, it did evoke some opposition, including from the Women's Graduates Association, led by Hannah Sheehy-Skeffington, for example, who expressed concern that even at that time, it didn't recognise the variety of roles that women and men played, both within the home, within the family, and in public life. And there was concern expressed that it didn't reflect the promise of equality for all that was found in the Proclamation of Independence. In terms of looking at Article 41.2 and arguments for retaining it in its current form, these relate specifically to the kinds of roles that women have historically played within the home, within the family, and as carers. Women have taken primary responsibility for caring work and for caring for dependents, both within the home and in the wider community. And women continue to take most responsibility for care work in the home. Traditionally, in most societies, not just Ireland, that care work and those roles have been undervalued by society and by the state. So Article 41.2 can be seen as a recognition of the contributions that women historically have made within the home and in caring roles and in the wider society. So it's viewed as a recognition of that, of a kind of work that traditionally in most societies has been undervalued and remains undervalued. So in terms of retaining Article 41.2, there is an argument that it recognises the specific importance of the roles played by women as mothers, and that it achieves a balance against the demands of the marketplace, demands to participate in paid employment outside of the home, and it is a counterpoint against reductive kind of economic views of what economic development, what growth should be about, and what societal well-being is about. So it is a counterbalance to that by focusing in on roles of caring within the home, within the family. It has been argued that it provides a constitutional basis for claims to support the work that is undertaken by mothers in the home and for mothers' roles. That it provides a specific recognition within the Constitution of those roles and can provide support for the kinds of claims that are made by mothers and that could be made for state support. Now, I'm not going to go through the case law, as Gerry has already done that, but that hasn't played out in terms of the practice of the courts to date. It hasn't been given recognition as providing a legal basis for those kinds of claims, except in very limited circumstances, for example, with regard to the deserted wives payments that previously existed in the Social Welfare Code. The arguments for reform come from different perspectives and represent different kinds of arguments. One is that Article 41.2, as it's currently drafted, doesn't recognise the roles of all of those who care for dependents and their contributions to society. So Article 41.2, as it's currently drafted, relates specifically to the roles and duties of women and to the roles of mothers within the home. And that is what the constitutional text refers to. Former Judge Murray has, as Gerry mentioned, suggested that it could be interpreted more broadly to include the roles played by fathers within the home. But a plain reading of the text of the Constitution is that it refers specifically to women and to mothers' roles. So in terms of that reading of the constitutional text itself, it is argued that it doesn't provide any recognition to the roles played by men within the home, the roles of men as carers and the duties of men both within the home as carers and as fathers. So that isn't referred to in the text at present. An argument that is linked to that is the concern that as currently drafted, the constitutional text is based on a stereotyped view of distinct roles for women and men in society. And that view is now outdated and doesn't reflect the variety of roles played by women outside of the home, in public life and communities, in society more widely. It has also been suggested, and some concern has been expressed, even at the time of the drafting of the Constitution by the former Attorney General, Costello, there was concern expressed that the specific reference to women's duties and roles within the home could undermine and take away from wider protections given with regard to equal protection before the law concerning women's other kinds of roles in employment, in public life, for example. So there has been concern that it undermines those protections and is in tension with those. Today we would find those protections in the employment equality legislation and in the equal status legislation, for example. Arguments for reform have included the proposal that we should remove this stereotypical reference to the role of women and to mothers' duties within the home. Those arguments have come from a range of sources, including the Irish Human Rights Commission. But these arguments have also attracted the attention of several UN human rights bodies and of the International Labour Organization. Just to give you one or two examples, the UN Human Rights Committee, for example, which is a human rights treaty body which monitors Ireland's compliance with international human rights law and specifically the International Covenant on Civil and Political Rights. In 2008, they expressed concern that this provision of the Irish Constitution perpetuates traditional attitudes towards the restricted role of women in public life, in society and in the family. The International Labour Organization has expressed concern that this provision would come into conflict with anti-discrimination laws and protections regarding equality in employment. The UN Committee on the Elimination of All Forms of Discrimination Against Women, the CEDAW Committee, has expressed concern that this provision is based on a persistence of traditional stereotypical views of the social roles and responsibilities of women and men in family and in society. So those concerns have been expressed over several years and in repeated concluding observations on Ireland's record in terms of complying with international human rights law. Another kind of argument that has been made for reform is one that is linked to the view that Article 41.2, as it's currently drafted, does not provide the kind of legal protection that it was hoped it might for carers' roles within the home and even for women's roles and mothers' roles within the home, that it hasn't been given that kind of traction and recognition by the courts. So another argument for reform is that we should retain reference to the role and value of care work and of the contributions made by carers, but that Article 41.2 needs to be strengthened. It needs to go beyond an obligation placed on the state to endeavour to safeguard carers' roles, and it should provide protection for the roles of all carers. In the synod case that Gerry mentioned, for example, Justice Denham, as she then was, Justice Susan Denham, did argue that Article 41.2 was a positive recognition of the roles that women played as carers. In fact, however, the majority of the court, and Chief Justice Keane, for example, as he then was, said that while Cathy Sinnott's role as a primary carer for her disabled son, that invoked respect, admiration and compassion, but it didn't support a legal claim for compensation from the state for failing to support her role as a carer. So it didn't provide the kind of legal protection that it might have, although it evoked respect and admiration. So looking at the value of care and the contribution that Article 41.2 might make, it's argued that it is a positive recognition of the value of care work and could be. It could provide important recognition of the role of carers in society and the value of their work. Care, it is argued, is a central concern of human life and should be, and it is founded in the inevitable vulnerability of the human condition. We are all vulnerable at some point, at some time. We will all need the care of others at some point in time, and that should have constitutional recognition. It's also important to support the work of carers, but also the rights of the recipients of care, those who are receiving care as dependents, whether as people with disabilities, as children, as elderly. The rights of those who receive care should also be given recognition in some constitutional reference to the value of care. In terms of the reform proposals, these are all set out in the various submissions. The Constitution Review Group did look in some detail at Article 41.2 and suggested a rewording of Article 41.2 that would remove the gender specificity, the reference to women and mothers' duties within the home, and that instead would be reworded in a gender-neutral way. That would recognise the role of carers within the home and family life and its contribution to the common good, but removing the specific reference to women and to mothers. Again, the Oireachtas Committee on the Constitution has suggested a rewording of Article 41.2 that would be gender neutral. That again would recognise, in this context, the Oireachtas Committee referred specifically to the roles of parents in its rewording and the roles of both parents and duties within the home. In terms of the submissions that you have before you today, you will see the proposed rewording brought forward by Quorum, for example, which is supported by the Iona Institute in this proposal, and that is that the rewording should be gender neutral, but should include a recognition of all unremunerated parents and carers and the work that they contribute to society, but that it should not be limited to parental roles. The wording of the Oireachtas Committee referred specifically to parental roles. The suggestion is that we could have a rewording that would take account of the roles of all carers for dependents, including those who may be caring for the elderly, for example, or for people with disabilities, but not necessarily in a parental role. The National Women's Council of Ireland has again proposed a rewording that retains a recognition of the value of care and care work that would include recognition of the roles played by all carers and their contribution to society, but they would also look at the significance and importance of care work outside of the home. So not confining the reference to care and caring roles within the home, but including reference to care work that might occur outside of the home in the wider community, in neighbourhoods, etc. Okay, thank you.
Thank you very much.